My name is Michael Sauers. I am the Technology Innovation Librarian at the Nebraska Library Commission, and my co-moderators.
I'm Laura Johnson, and I'm the Continuing Education Coordinator at the Nebraska Library Commission.
And we would like to point out, very important, we are not lawyers. Okay, let's make that straight. But we both deal with this issue a lot. I'm just interested in it, and always kind of have been in my library career. Laura gets phone calls and questions from people about, can I use these things? I get those questions too. And we've attended a lot of sessions from others on copyright issues. Usually a lawyer or two is involved. And we survive them, but we always have complaints about how the material was presented and disagreements and blah, blah, blah. So we finally said, okay, fine, we better start doing one of our own. So what we have done is we've kind of based this on questions we commonly get and issues that are commonly raised. Okay? Now, we're generally not going to get into specifics when it comes to like classroom use in academics or schools, because those are some other very specific situations. But all of the stuff we talk about still applies. So we're trying to be kind of generalized in this case. So what we are going to do is as we get to each topic, we're going to survey the room. Okay. So it's just going to be a hand raise. There's no, well, okay, there are right and wrong answers, but that's okay. That's why you're here. So we'll start with our very first question. Okay, we'll start out with the basics here. Where is copyright codified? Is it A, in the Constitution, B, in the U.S. Code, C, in the National Commission on New Technological Use of Copyrighted Works, or CONTU, or D, all of the above? So, who thinks it's A? Okay, nobody. B? 1. Okay. C? 4. Okay. D? Alright, D. Yes, D is the right answer. Okay. Now, it is in the Constitution. In fact, Laura, I think you take this. So.
Yes. It's in the U.S. Constitution. The copyright was considered important enough to put in the Constitution. So this is really a very fundamental thing. However, as you see, the copyright was meant to promote the progress of science and useful arts by securing for limited times to authors and inventors. So maybe the purpose of copyright has kind of changed over the years. But this is what the Constitution originally does say, and I think that's an important thing to keep in mind, because that helps us kind of, when you have to make judgment calls, think about where you're at with it.
And you want to briefly discuss B and C there? Because we didn't say all of the above.
The U.S. Code has, a whole long section about copyright and what the exceptions are, and we'll come to that later because those exceptions are very important to us. Then the National Commission on New Technological Uses of Copyrighted Works. These guidelines came about for people who are doing, actually a lot of the academic people who are doing a lot of interlibrary loan, that kind of thing. And this, of course, is not really, this does not have the force of law. This simply has the force of an agreement among people as to how they're going to handle things. But it's still a useful tool to us. So kind of all of these things are what helps us figure out what copyright is. And of course, any time that you're talking about law, we have to remember that law comes from essentially 3 places, or 3 levels of law. First, it comes from legislation, or the Constitution. It comes from written code. Second, it comes from regulation, where the written code essentially authorizes an agency to create regulations about things. That's what the Federal Register is all about. And then C, it comes from court cases.
Case law.
It comes from case law. And case law is very important because, of course, our law is really kind of based on the idea of precedent. And it's based on what's been decided in the past. So it's great that we can point to the Constitution. It's great that we can point to the code. but we also have to think about case law and what's happened before. And one of the problems with a copyright is there's not actually a lot of case law. So sometimes a lot of this can come down to a matter of opinion or what the judge thought or whatever.
And no matter what the Constitution says, someone can still sue you. So,
Yes, anybody can sue you anytime.
the Constitution might be your defense, but yeah. And I like the limited times part. That has been decided that the Congress gets to decide what limited times are. That was a famous Supreme Court case of just probably only about a decade ago. The last time they extended copyright law significantly. It went all the way to the Supreme Court, and the argument against the extension is this is limited times, and when we're talking like lifetime plus 70 plus something years of an author, is that really a limited time? And the Supreme Court said, well, if that's what Congress says a limited time is, that's what a limited time is. So we are kind of stuck with that just a little bit.
Yeah.
All right, so next question: is this presentation copyrighted? Yes, automatically, unless it says otherwise. No, I haven't seen a copyright symbol or statement. Or C, no, governments can't claim copyright. So, A. Okay. B. No B's. Well, a lot of A's, no B's. C. Okay. Kind of a trick question. But if you picked A, that was the best answer. Okay. Generally, by default, anything once it is in what's called a fixed tangible medium is under copyright. We haven't had to put a copyright symbol on things since 1976. Okay. But you can register your copyright with the Library of Congress, the Copyright Office, and really the only thing that registration helps you with is if there is then later you want to sue somebody over violating your copyright, that will help your case. But it is not required to do so. So we don't need that. So yes, it says otherwise. C is kind of tricky. Okay, and it's good that nobody picked C. What if we were from the federal government? Could we claim copyright? Okay, I'm saying and shaking head no. Yeah, okay. The U.S. federal government cannot hold a copyright. Okay, now. But that doesn't mean like because it was government funded doesn't mean somebody else couldn't hold the copyright. I mean, it gets a little tricky. But like the Federal Register is not copyrighted U.S. government. It is public record. Doesn't have the copyright. The state of Nebraska can hold copyrights. That was one of my first questions when I got this job. Okay. Now there is a giant exception to all of this, and this just overruled everything I just said. Yes, it's copyrighted, but we have decided to license this under what's known as Creative Commons. How many of you are familiar with Creative Commons? Okay, about most of the room. Okay, so I won't go into too much detail, but a lot of the stuff we put on social media, our blog, things like that, we've licensed. So, yes, it's copyrighted, but we're kind of giving you permission in advance to reuse this material, providing you follow, in this case, a license that's called Attribution Non-Commercial. And you give us credit, and you don't use it for commercial purposes or don't make money off of it. And I could spend a half an hour talking about what do we mean by commercial here, but that's a different presentation. So yes, it's copyrighted, but if you want to use this, go right ahead. All right, here we go. I need an image for my website, and I found a great one on Google. I can just use it, right? A, yes.
And?
Nobody. B, no. 1. C, maybe.
There you go.
Okay. So our answer slide's kind of a trick here, but I'm going to throw it in there. Okay. The answer isn't no. The answer is C, maybe. Okay. But it's this question that made us do this session. We have sat in on copyright presentations where somebody asked, I found it on Google, I can just use it, right? And you hear every answer from yes to, well, if they didn't want somebody else to use it, they wouldn't have put it online, to, well, of course you can because it's just copy and paste and whatever. And it's like, no! Okay? So that just doesn't keep playing. I'll back up a slide here. It is maybe, okay? Because we are going to talk about fair use, okay? There may be a use for that. But before we get to fair use, let me talk about Google image search for just a moment. Okay. How many of us use Google image search to find stuff? Okay, great. Okay. Do you know that under more tools or search tools, there is now an option called usage rights? And you can say, only show me the stuff where the person who created it in the first place has authorized its reuse. Generally, that's going to be under Creative Commons. Right? Or they marked it as public domain or something like that. So you can find images through Google image search that you know up front are going to be okay to use. Now, I will admit that generally limits your results pretty quickly and a lot, but you can probably find something that you're looking for. What I like to use for a lot of my presentations, though not this one, stay tuned for the next session, you'll see examples of this, is Flickr. And you can also limit your Flickr search results to things that are licensed under Creative Commons for you to reuse, generally assuming as long as you give credit. So the answer is maybe in that, as long as you kind of pay attention to what's going on, use the tools that are available, and then there is always fair use that we can fall back onto, and we will be getting to that in short order.
And what's a corollary of this? Come on. Work with me here. Corollary is, if you're putting up images, how about taking a little extra time to make sure that you are putting them up under Creative Commons so other people can use them. If it's really something that you could share, how about taking the extra minute to share it? It's going to make life for everybody a little better.
You know, for me, it's kind of fun when I go see someone else's presentation and they use one of my photos as the example. Gave me credit.
So,
yes.
Okay, I know how to do that on Flickr.
Yes.
But how would you do that, like if you uploaded it to our library blog or something? Or how do you?
Not to get too far into the weeds here.
Right.
But if you do license your blog under Creative Commons, you should be able to get some code you can put in the metadata for the page that says the content of this page is licensed under Creative Commons.
Oh, okay.
And then the Google search will pick that up. All right. So fair use. So this is kind of the ultimate concept here. This is the other thing that kind of drives my interest in copyright. Fair use is a four-pronged test. Fair use is a defense. So the only way to actually prove that your use was fair use was to get sued and win, which makes lots of people nervous. So that's why when I see these amazing flowcharts online that is like, can I use this work or not? One of the more recent ones I saw, the very first question was, can you get permission to reuse it? Yes or no? And if the answer was no, then it said, is your use fair use? And I'm sorry, that's backwards. You consider whether it's fair use first, and if you think it's not, then do you need to then try to get permission. And I want to stress this because it's my belief, we're getting a little political here, but we've kind of already done that, is that we're kind of giving up fair use. Because when you ask permission one time, you then have to ask permission the next time, and since you ask permission, the next person has to ask permission. You don't always have to be afraid. The four-pronged test is, and then I added Creative Commons at the bottom, the purpose and character of the new work. So generally what this is going to be is, are you using it for commentary or criticism or parody? If you're doing that, that is generally considered a fair use, and there's plenty of case law on that one.
This is in the code, US code.
This is in US code.
And unfortunately, yes, it is vague.
The nature of the copied work. If you're copying bits out of a novel versus a whole photograph, there are different considerations to think about when it comes to that, because that also then is the amount and substantiability, I hate that word, of the original work. How much of it are you using? And especially when it comes to academics, and we mentioned the Contu guidelines, these are the sorts of things that are talked about in the Contu guidelines. How many pages is too many? How many copies can you make for a course pack? That sort of thing. There may not be actual case law on it, but the Contu guidelines are trying to make you stop before it would become a case law, a case. And then this one, effect upon the original work's value. So I'm not making any money off of it, so it's okay, right? Yeah, not so much. Okay. The idea is not whether or not you're making money off of it. The idea is whether or not you're taking money away from the original person.
And if you look at what the Constitution said, maybe that's a little different than what the Constitution originally said its purpose was. But this is kind of where we're at. We're protecting Mickey Mouse. Literally.
Yeah,
we're not kidding here.
Watch what years they've extended the copyright law and what years Mickey Mouse would have gone into the public domain. They kind of line up really nice.
Yeah. If you look at the code, they do talk a little bit more about this. You also want to, okay, I'm going to go out on a limb here.
Go for it.
If you talk to a lawyer about this, or your institutional lawyer, a lawyer is going to more or less by default not want to take a risk. So he's going to be extremely conservative about this. So some of this does come down to your willingness to take a risk. Are you likely to get sued? Well, the fact of the matter is anybody can sue you anytime for anything. And you're less likely to get sued than you are to get a letter saying, hey, cut that out. So you have to weigh these things. And this is kind of one of those policy decisions that your institution is going to want to make. But you don't have to be terrified and never use anything, we would say.
Yep.
We're pretty willing to take a risk. Because if somebody sued me, what would they get?
I'm a librarian. MLS makes lower salary. Right, yeah, okay. I throw in Creative Commons in the end because Creative Commons can kind of cover your butt in all of this and say, well, the person gave me permission in advance. The one I love here, if you like looking through YouTube, start watching YouTube video descriptions, and I love the ones where they uploaded a whole movie and then they put no copyright intended, which they mean no copyright infringement intended, but like, that is not a defense. I didn't mean to violate copyright when I did this. Well, okay, but you did. That's not, so...
Actually, if you put that on it, probably you did violate.
Right, yeah, you're probably waving a big red flag saying, I know this isn't okay. All right, so next question. If you use an image or quotation or clip, do you have to cite the source or give credit? A, if you give attribution, then you can use it. B, yes, this is a matter of good scholarship and librarianship, not of copyright. C, if you're using the material under a Creative Commons license. So who thinks A? Nobody? Okay. B?
There you go!
You passed the librarian test. No. And C, maybe if you're using the material under a Creative Commons license. Okay. It is B and C.
Yeah.
Okay. It's just good practice to cite your sources.
It's good manners.
It's good manners to cite your sources, even if it's completely fair use. Right? Now, I'll admit I've used clip art and not cite my sources, and there's judgment calls here. But really, copyright does not require you cite anything. But not citing could be an issue, but really it's just good scholarship. C, correct, but yeah, you get into plagiarism if you're not citing your sources in some cases. Then if you're claiming it as your own, another presentation. C, maybe if you're using the material under a Creative Commons license, most Creative Commons licenses do require you to cite your source, to give credit. There is one small exception with a license called CC0, which almost nobody uses. It's kind of like public domain, but isn't. Long story. I've had people use my photos in presentations, friends of mine, and I kind of go up to the end of it and I'm like, thank you, and I really hate to mention this, but there's no Michael took this photo or link back to my source, and every single one have gone, oh crap, sorry, and updated their slides to put it in. It was usually a mistake. But especially when I learn them, I hate to bug them, but please follow my license. So, yeah, and I just throw this in here. This is the Wikipedia page for Wales, where a couple of citations are needed. Sorry. Yeah, okay. All right. Okay, here we go. We actually got this question.
Yeah.
Is it legal to read a book out loud at story time? A, of course, it's not like anyone's going to suggest otherwise. B, yes, because it's fair use. C, due to a specific exception in the copyright law. Or D, technically no, since it's an unauthorized public performance. Okay, so A, okay, B, okay, a couple of B's. C, okay, a couple of B, C's, and D. A couple of D's. Nobody's really sure on this one. Laura?
Really kind of see. There is a specific, I forget what it's called. There is a specific thing that says, okay, you can do a public performance if you're doing a public performance of a work that wasn't meant to be publicly performed.
So a non-dramatic work.
So if it was a play, you can't do it. Then you're violating copyright. But if you're reading a book, if you're doing a performance of a book, it's probably okay. Again, non-commercially.
Don't charge admission.
You can't charge, yeah, and you probably couldn't put putting a video of yourself on the web reading it, that gets a little trickier. But doing it in your library for a group of people, you're okay.
Yeah, this one came up because somebody was asking the question, and I just, for fun, I threw out, well, isn't that an unauthorized public performance? And like you wouldn't believe the tizzy that happened in the conversation at that point, because it was this, all of these librarians who never really thought of it that way. We've just been doing it forever, you know. So we throw that in. But yeah, you're covered there. You're good on that one. Okay. A patron told you she's taking home CDs, making copies, and returning them. What should you do? Oh, I love the looks of it. A, nothing, it's none of my business. B, sit them down, have a little chat about copyright, then let it go. Or C, have that chat, and if they keep doing it, cut them off. Okay. You thought this was going to be a boring, okay. A. Okay, we got 2 A's. B. About 6 or 7 B's, and C. Okay, the hard nose in the room. The one, yeah, cut them off. Laura, what do you think?
I think you should put your fingers in your ears and go la 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 la. I'm telling you this. Try not to know this. We're talking here more about ethical or moral responsibility than we are about legal. Kind of.
Yeah.
It's none of your business. Remember, it's privacy. We don't comment on what people check out at the library. We don't keep track of what they check out. So you're not supposed to know this. And, just don't let people tell you things. But if they tell you, how morally responsible or ethically responsible do you feel? And is talking about it with them then making you more responsible? I would say it does. Legally, it probably does. I'm not a lawyer.
Now we're kind of also talking publics.
Yeah.
If you have an educational duty in a school or in an academia, then I would definitely lean more towards B.
Yeah.
C kind of gets into now institutional policy issues. Yes, please, input.
Where I objected was having the chat with them. What I probably would do would point to every sign we've got on the piece and say, this is here. And
Yeah,
then I'm done.
Yeah, that's kind of the B.
They know it.
Right,
and then I'm done.
right.
You do want to have a sign, though, somewhere that says, hey, don't do that.
But yeah. Oh, you stuck them on every single CD? Oh, okay.
Yeah.
On every single case.
On every
Yeah.
case, okay.
Every
Well,
DVD, every CD thing.
you've heard, that's the chat, you just had it. I mean,
Yeah.
and, but yeah, it does fall into one of those, please don't tell me that categories. I
Yeah.
really don't want to know. Okay. May the library use one of the director's monthly newspaper columns in our library newsletter? So the director is writing a column for the local newspaper. Can we reprint it? Yes, as long as the library director is okay with it. No, the newspaper owns the copyright. The library may not use the material without their permission. Or C, maybe, what does the contract say? So how about A? Nobody's picked A. B? 1B? C? Everybody else. Yeah, it's C. This is a contractual issue. Who owns the copyright?
And you guys have figured out that the answer is almost always maybe.
Sensing a theme here. But what we're trying to do is to help you make the guests educated. But yeah, it is a contractual issue. I've signed book contracts, I've signed writing contracts, and there are clauses about reprint rights and all these other things. There is also a clause that will say who owns the copyright. And in the latest book I'm writing, it said the publisher would be listed as the copyright owner. And I said, you know what? Nah. How about me and my co-author? And they went, okay. So we have the copyright. Now, the contract still says that they had the right to do foreign sales and ebooks and some other things, but there should be, in this situation, some sort of contract. Now, maybe there isn't. It's small town library, small town paper. The director's just been sending it in for years. I tend to lean towards ask for forgiveness, not permission. But if the town's that small, just call the editor and say, hey, we're going to reprint this. Do you care? And my guess is they'll say no.
You know that when that's over.
But this does kind of mean that maybe you need to think about things like agreements. I don't want to be legalistic. I don't want to put a lot of, sort of infrastructure in place that you think you don't need. But on the other hand, an ounce of prevention is worth a pound of cure. So maybe you do need to think about having agreements for this kind of thing, if you're going to do this kind of thing. Just a thought.
Okay. All right. If my library requests a photocopy of a magazine article through interlibrary loan, may we request another article from the same issue again in 6 months? We've actually had this question.
Yeah.
A, yes. B, no. C, maybe. How many of you already requested? So, A? No A's. B? No B's. Wow, we got this one down. C? Yeah! All right. It is how many have you already requested? And hey, a photo a friend of mine took, and here's the credit for it under Creative Commons. Yeah, it is. Okay, can you keep this straight? It's 3 and 6 months, 2 and 6 months from the same source, and it is the borrower's responsibility to keep track of this and pay any licensing that may be involved because of it, not the lender. And
you can lend as many copies of something as you want.
it's borrowing. And, considering we do ILL for a lot of libraries in this state, we got somebody who knows this stuff. And in Linda's case, sometimes she will talk to some libraries saying, hey, you're borrowing an awful lot, but it is not, it's their responsibility to ultimately keep track of it. We just do because we're an intermediary agency.
Ask for different libraries.
I don't think that matters. It's the content, not the source. Yeah. Yep. So, yeah, and we don't want to turn this into an ILL presentation because we're the wrong people to do that. Okay. May we use a copy of the book cover to put on a flyer for our book club or on our website? A, no, not without specific permission. B, yes, this is within the doctrine of fair use. C, yes, this is a useful article. Okay, so A. Okay, one squinty face, no hands. Okay, yes, I can see all of you. It's a small group. I didn't identify the person. B, yes, it falls within fair use. Okay, about 50% B's, and C, yes, this is a useful article. Kind of 1.5, sort of. Okay. I'm actually impressed that you picked useful article because that means you've heard of the concept of useful article. But no, the C is not the answer. B is the answer. And this one, this has been an issue within many institutions we know lately, and we have a copyright guy, Rich Leitner at UNL. He's like the head of the law library, and is a copyright guy, and we called him up, and he went, yeah. I mean, really, that was his answer. It was just like, yeah, you can do that. Don't worry about it. You don't need to get permission. It's commentary, it's criticism. You're advertising the fact that you have the book in the collection. However, I have been talked back. There is a section of the copyright law called useful articles. And I was briefed for about a year arguing that this is a useful article and the fact that it's advertising the product or whatever, and I've since been corrected on that. Books have never been considered a useful article, and I'm just going to stop there. So it is definitely not C, but it is B, and this is fair use. Yes?
Do you have to own the book?
No.
No.
Okay.
And here's our defense, even before we talk to our lawyer, okay? Publishers Weekly does not call every single publisher in the world of book they're going to review and say, can we print your book cover in our magazine? They just don't. It's fair use. It's commentary. It's criticism. It's okay to do. Yeah, maybe I've heard a story of an author calling up somebody and saying, don't do that ever again, to which you could just say, okay, fine, I'll take it down. Or the author may not actually own the copyright to the cover. So then it gets really weird. And I'm not sure you want to get into an argument with the author over their book cover. Because if nothing else, they probably have the contract in hand, even though they might not be correct in what it says. But yeah, this is fair use. We can use book covers. It's fine. Just do it, please.
Oh, you can use a book cover in a review. In a ad that you have the book. Using the book cover, the art from the book cover to do something else.
Well, yeah, there's the transformative. If you found a copy of the book cover that is the artwork used on the book cover, but not the title, well, the original source art, then maybe we're getting a little trickier too, because now you're talking about the artist's rights to reproduce their work. So ultimately, you can get into some gray areas. But really, if you're writing a blog post that says, hey, we got these 6 new books, you're fine. It's okay.
And if you need a book cover, by the way, Library Thing's the way to go.
It's spectacular.
Yeah, they have a good source of the book covers. And if you want to see something interesting about this, go to Eric Carl's website. Eric Carl's, the children's author, wrote The Hungry Caterpillar and other things. And he has a whole section on his website about how to use his work in the library if you want to, and how you ask for permission. And we have actually seen where somebody asks for permission, and the publisher just sends this little form letter that says, oh yeah, here you go. Use any of our book covers you want to advertise books. So, this is something actually you probably should feel fairly comfortable about. But, again, if you're going to use that artwork for something else, then you might need to think about it.
Which leads us to our next question.
Yeah.
Oh, quick, yes, question.
You mentioned library something.
Librarything.com.
Librarything. Yeah. Is it .com?
Yep.
Okay.
May we enlarge one of the illustrations from a book and paint it on the wall of the children's room as a mural? A, no, that's stealing. B, yes, it's fair use. C, maybe if the illustration is old enough to be out of copyright. So how about A? Okay, nobody's okay. B, fair use. Okay, nobody called that. And C, maybe out of copyright. Yeah, okay.
Yeah.
If it's out of copyright, go for it. If it's in copyright, and we're talking, I've read a book on fair use and usage rights when it comes to like photographic and artworks, and it was written for museums and archives and things like that. And at the end of the book, I was just like, I am more confused than I started with. I was, and it was only like 100 pages, but still, and this was like guidelines for how to do it, and I was still completely lost when I was done, because it does get really complicated really fast. But if it's out of copyright, pre-1923, you're pretty much fine to do that. But there can be fair use, okay? Could you do this? Okay, kind of reproduce the originals? Probably not. Could you, however, turn them into Orange is the New Black posters? Probably. Disney still likes to sue people, but because Commentary, criticism, parody, transformative, probably okay. Can your elementary school reproduce Harold and the Purple Crayon and hang it in the local community college? Which is funny, I need Jake in here because Jake has a tattoo of Harold and the Purple Crayon on his arm, and I meant to get a picture of it. Definitely not, probably okay. Are you going to sue third graders? Okay, but yeah, just watch it, because artwork is a really, really touchy situation there. Although you're probably not going to do this version on your library wall. Oh, it'd be really cool if you did. Let me know. I'll come take a picture.
But Disney, they're pretty protective.
Okay, the library may show a movie at a library program. Yes, no, or maybe. So what do you think? Just shout out. Maybe. Yeah, all right. Laura?
Okay.
This is our department, literally.
You do need a performance license in order to be within copyright. The Nebraska Library Commission actually pays for a performance license for all public libraries in Nebraska to show movies. So we're trying to keep you legal. Having said that, you can only show the movies that are on a particular list, so you have to go to the website and look to see if the movie is there. Although a lot of movies are there, so it's not a matter of choosing among 20 old movies. There's a lot of movies. You do not have to own the movie yourself. You can only show it in the library. You can't show it at the community center. You can't show it on the outside of the building. When you advertise the movie, you can't use the title of the movie, and you can't charge admission. But if you want to sell popcorn, you're cool. So there are strictures, there are limitations to this, but basically, yes, and this is a great way to do library programming, and we'd love to encourage you to do this, to show movies. Yes, ma'am.
When people host movie in the park nights and stuff, they're asking specific permission from the film company?
You can ask specific permission.
Okay.
You can pay a one-time fee
performance fee
to use a movie, but if you're doing it under this license, you're wrong.
If you are, I know Dave Mixdorf here at South Sioux City does do some sort of outdoor film festival in the summer, which would not be covered under the license we get for him. So I would, he could probably point you in the right direction specifically. Although I know they did 1950s B movies would still be under copyright at this point, as cruddy as they are.
Yeah.
So let's go up here and then we'll go back again. Yes.
I have a question. Who do you get your licensing through for the library?
Oh gosh, what is
I'm
it?
with the school library.
Is it movie licensing?
I think it's movie licensing. Go to our webpage
Yeah,
and search.
that's who I subscribe to too.
Yeah.
I think if you read their small print for schools, even for my license, I can show it like in the gym. But you're right.
Well, you're still in the same
You're still in the
building.
building.
Yeah, you're still in the
Not
building.
on the outside.
Yeah,
That's
but we can't, for instance, in the library, show
I
it
just
in
wondered if
community
you had
center
another one.
down the street.
another vendor that you use, because sometimes I get a little frustrated.
I think there are a
with the
couple of
licensing.
different vendors, but this is the one we have. We renew it every year. We get a bunch of certificates, and we do send them out to the public libraries. So if you have any questions, it's Sally Snyder who usually does this every year at our office. But it's every fall.
Yep. Follow up with the back.
Sorry, I think I answered my own question.
Okay.
If it's being broadcast, obviously it's not in a fixed format, therefore it's not copyrighted. So if you are projecting like a broadcasted live thing, say outdoors, like the World Cup or something like that.
Oh, I'm not even sure I want to go there.
Okay.
To be honest, because you get to the end of that broadcast and it says, bars pay licenses to show television in the bar.
Oh, really?
Yes.
Okay. All right.
Whether I think they should is a whole other conversation.
Okay.
But because it's kind of considered a commercial use of the television broadcaster's content.
But if you're not making people pay.
Right, well, okay, and anytime, and I'm glad you said that.
Yeah.
as much as I may agree with, but if you're not making money off of it, why isn't it okay?
Sure.
I agree with that in principle, but I know that's almost never a defense.
So someone owns the World Cup, even though it's like broadcasted live TV, and you can't, and it's not in a fixed format.
Well,
Well-
your definition of a fixed format is
Okay.
pretty loose in general.
Do you ever watch all the way to the end? There's actually a little statement
A little
at the end.
blurb about
They
it.
read to you about it.
Okay.
Now, what is your level of acceptable risk? Okay?
Good call.
You know, if I did that out in my backyard,
Yeah.
I really am not going to care at all. What are your chances of FIFA finding out that you broadcasted on the back wall of the library and suing the library or the town? Probably very small, in my estimation, okay? But what's the this is where if you ask a lawyer, the lawyer's going to say, no, don't do it. Because they don't want to take any chance whatsoever.
Yeah.
But I will just basically inform you that no, that is not a definition, clear-cut, fair
Okay.
use
Well, I'm
example
glad I
you're
asked
asking about.
then. And FIFA is kind of a criminal organization.
Well, yeah, I know. but
Maybe
they still own the
everyone
rights,
else
whether
yeah.
or not they do. So, but yeah, for films in the library, we're pretty covered. Now, when you do get to schools and academics, and there's instructional use, and there's all sorts of other issues that we just don't have time to get into on that. Okay, so what's the definition between a copyright and a trademark? A, copyright is automatic. B, trademark must be applied for. That's A. B, the U.S. Copyright Office is part of the Library of Congress, and the Trademark Office is part of the U.S. Trademark Office. C, copyright protection is the holders by right. A trademark must be defended. D, copyright is more far-reaching than trademark. And E, all of the above. Okay, just shout out what you think it is. It is E. It is all of the above. Okay.
Why does this matter?
Well, they're different things.
Yeah. And copyright, you have actually more far-reaching rights. Trademark is limited to a fairly narrow category. And trademarks must be defended. So every time somebody in public says, give me a Kleenex, Kimberly Clark needs to tell them, no, it's a Kleenex tissue. Because if they don't, it can pass into common parlance. This has happened to the word cellophane, the word aspirin. So you have to defend that trademark, which means you really need to be careful about trademark things. And it also means that they want Mickey Mouse to be copyrighted, not trademarked. I think though Tony the Tiger, I'm not sure, but I kind of think Tony may be trademarked, not copyrighted. And that does affect, how you, in other words, be careful about using Tony. Because by law, they pretty much have to go after you for that. If they find out about it. But remember that these are different things. They're both intellectual properties, but they are really different categories, and you kind of need to be aware of those differences. Okay?
That's it.
Yeah.
Got through all of them. We still have a little time, about 5 minutes. This is where we get a little nervous. Do you have any other questions? Because we were prepared for those. Any other situations you've run into? Just something you want to clarify? Yeah, Terry.
Well, we just ran into a trademark situation.
Okay.
And, words, we didn't think that words, so we had the cemetery tour. This year they picked the foundation, not the library, but the library foundation picked Believe It or Not.
Yeah.
Ooh, Ripley's.
As the title, but not Ripley's Believe It or Not. And Sarah looked through trying to see if it was copyrighted, because you can't copyright
No.
per se words, okay. And she looked, and of course, you can't really successfully search trademarks, she found out. She was looking.
It's hard.
Okay, so they went for it, but they kind of played it down. It was just on the posters on the tombstone.
Yeah.
Well, then the media picked it up. The, basically the Visit North Platte and put it at, believe it or not, cemetery tour. Well, then the Nebraska, tourism picked that up. Then it picked up and went out further, and literally the day of, or the Monday after we had the first 2 cemetery tours, we still had the evening one left. They get this letter. They send a letter to the Visit North Platte. They send a letter to the thing saying desist, and so then they gave the trademark numbers. But the question is on the trademark numbers, and said, cease and desist, otherwise we'll do it. So we had to pull everything off, except the only thing the tickets had it on. We could reprint everything else. Pulled all the posters down. But the question came in, could they really do that? Because, it was really crazy because when she looked up the trademark almost called it a logo, which would have specified the type of font.
Yeah.
But we finally found at the very bottom, so I looked up, I said, where do you find this? So I looked on their website, Ripley's Believe It or Not, and then on the very, very bottom in tiny, tiny, tiny print, it said, Believe It or Not and Ripley's, separating the 2 things were trademarked. But it was really a hard thing to research to find out.
Yeah, there's 2 factors there. One is they have to do that.
Yeah.
Because the moment they let one go, it starts to chip away at their rights.
So that was the defense. That's what I
Yeah.
Okay, like the Kleenex.
And then when it comes to trademark, if it actually went to court, sort of thing, then kind of what it usually centers around is likely to cause confusion. And so whether or not people would think that your use of it was actually them endorsing it, you could argue. But they still have to bring that suit to defend their trademark in the first place. Because if they don't, they might lose it.
It's also, as we said, when you trademark something, it's within a category. In other words, if you're...
McDonald's Hardware and McDonald's Burgers.
Yeah, they're fine.
Right.
So it may be, is that within the same category, and it might be, as far as the trademark office. But this is what keeps intellectual property lawyers in business.
Employed, yes. Now, if McDonald's Hardware started using a golden letter M, then there's likely to cause confusion, and so the name McDonald's is trademarked, but that logo is also trademarked. Now you can parody a logo. I mean, we've all seen funny versions of logos that people have done online. There's this guy, I saw one recently that was like the logo, and then if their slogan was what people really thought. And the only one I remember was it was the Pepsi logo, and underneath that it said, would Pepsi be okay? Because you always say, I want a Coke, and would Pepsi be okay? But that's parody, so they're not really going to get sued for that, for trademark infringement, because it's not really trying to advertise something else and cause confusion, it's making fun of it. Yes?
And it may depend on the company, because actually
Yes.
my original interest in copyright came about back when I was a medical librarian, and for a Mid-Continental Medical Library Association, Mark Funk and Bob Pashota and I and some other people created a poster, Dewey's Believe It or Not. Same group. And it was a parody, and all of, we got the cease and desist.
You did too? Yeah.
So they're pretty careful about their...
Yeah, they're...
That Believe It or Not.
Yeah.
And I think that's why they separated it.
Yep.
And parody, it should have been under that, but...
Well, and okay, you were parodying it, but you were parodying it to market something else too. It wasn't just a straight.
we were giving away
you were just
posters free.
all right.
It was a free poster.
Yeah, and these days, all they got to do is set up a Google alert on Believe It or Not, and the moment it hits anything online, they'll find it. Thank you all. We're done.
Thank you.
Yay!
I've got one more minute.
Oh, it's way over.